it is about transparency. Over and above the transparency and accountability aspect of it, I think it is equally important to state that the issue of recovery of looted assets is an issue that has international dimension and colorations. For example, Financial Action Task Force is an agency that is responsible internationally, in respect of which over 100 countries are involved. And there is the sharing of intelligence. There is aspect of demand for international uniformity, both in terms of legal and institutional framework. And then if Nigeria now does not satisfy the legal and institutional requirement of it, it makes it very difficult for Nigeria to have the support, to have the understanding and working understanding and relationship with Financial Action Task Force.
Okay, so that is the latest commentary coming through from the AGF. That was at a FEC meeting yesterday. So there's this agency that will be set up if certain things eventually go through. The bill, for instance, which the AGF was talking about there. Well, to shed some light on what he's spoken about, the implications and what it does mean, we've got some gentlemen joining us this morning. We've got Honorable Oladile Kaide, who is a former Chairman, House Committee on Narcotics, Financial Crimes and Anti-Corruption. He joins us from the state. We also do have Evia Richards, Executive Director, Corruption Observatory. Gentlemen, thank you for joining us today. Let me start with you, Mr. Richards. Now, there will always be several impressions about the intendment of this process and the outcome should it go through. Now, from what you've read and heard about what the government plans to do with this new bill, what do you think of it?
Well, the truth of the matter is that the issue of loot is a very, very serious one. Highlighting the fact that Nigeria is a very strong and resilient country to be able to withstand the kind of loot that has been inflicted on it over time. Let me just put a background to this. There have been several loot going on in the land, but the one that is in the front burner is that of Abacha, and which about 6 regimes have made recovery over time. The TI put that loot the upward of about $5 billion. Absalami Abubakar regime recovered about 750 million. Obasanjo regime in the first instance recovered about 1.2 billion in 2002. 149 million from the JC Island in the UK in 2003, 500 million from Switzerland in 2004, and 458 million in 2005. Yar'Adua did not recover anything. Jonathan's administration recovered 1 billion in the first instance in 2012, 380 million in 2015, 227 million in 2014, and 48 million that same 2014 from the US. Buhari's administration recovered 322 million in 2017, and then the latest of about 308 million in February 2020. And of all these recoveries, you know that Nigerians have been crying over how the money is being expended. In fact, it got to an extent that those releasing the monies have now decided to put conditions on how the money should be spent. And it is no news that these recovered funds are being relooted. And if any solution is being propounded on how accountability can be ensured in the usage of this money, I think it's a very welcome development. But let me say that the Financial Action Task Force is an intergovernmental body that helps in the recovery of this kind of money, also dissuading issues of terrorism, money laundering, banditry, and all that, and may really not have that bite, to begin to dictate how these monies are spent in the various countries to which they are being recovered into.
All right, let's take it to Honorable Oladile. Well, you've been involved in some of these bills. I mean, some of them were signed, were approved previously, but it wasn't assented to, as it were. But speak to that, perhaps in relation as well to the impression that some people have that trying to create a new agency to coordinate some of the activities and then looted funds, which may be domiciled in the CBN, depending on how this eventually goes through something. Isn't this going to whittle down the powers of the EFCC? Wouldn't there be overlapping functions with some of the other already existing agencies about this one now?
Thank you very much, Chamberlain. As a matter of fact, it's not going to be a replication of the existing laws. Let me just say this. Why process of crime bill? Let me just ask that question and then I will answer it. Under the Nigerian criminal justice system, criminal trials are usually prolonged through sometimes most often at the instance of the accused persons. And until there is a conviction, it will be difficult for courts to order final forfeiture of confiscated assets. This is why assets deteriorate in EFCC custody, for instance. Most of the assets are being held under interim forfeiture orders until there is a conviction. Section 20 of the EFCC Act, for instance, talks about courts making a consequential order of final forfeiture after conviction. Under the POCA regime, the action we're going to have is going to be an interim action against property. That is, the burden is going to be on the owner of the property to prove legitimate ownership and source of income. Under the extant laws, the ICPC Act, the EFCC Act, it is difficult to file an action against property because the person must first be convicted before he can get a final forfeiture. Therefore,
all right, we just needed to just mute some of the audio, so it was interfering with what he was saying, so we couldn't make out much of it. But pardon me, Honorable Oladile, for that. But if you don't mind, could you just go ahead and go over that again? Apologies, please.
Okay, you want me to start again?
Please.
I said under the current criminal justice system in Nigeria, criminal trials are usually prolonged. Sometimes at the instance of the accused persons, and until there's a conviction, it will be difficult for courts to order final forfeiture of confiscated assets. This is why I said many assets deteriorate in the EFCC custody, even in the ICPC custody. Most of the assets are being held under interim forfeiture orders, and until there's a conviction, you cannot dispose of these properties. Let's talk about Section 20 of the EFCC Act, for instance, says that it is after the conviction of a person that the court will now make a consequential order of forfeiture of that person's property or assets that have been held under interim order. So, and if this is not done, sometimes it can take eight years to complete, then the properties will be deteriorating. So, under the process of crime bill, what we intend to do, or the government is trying to do, is to bring a regime whereby we're going to have an action in rem against the property. So the burden will be on the owner to prove legitimate ownership and source of income. So today, because there is no such provision in the EFCC Act or the ICPC Act, both the EFCC and the ICPC utilize Section 17 of the Advanced Fee Fraud Act to go through the process of interim of a civil forfeiture. That is on the domestic front. But there are four reasons why passage of Process of Crime Act is very, very important. The first one I've said is the domestic need for civil forfeiture prosecution. I said it that the ICPC, the EFCC Act, for instance, have no provision for civil forfeiture. As a result, they use section. The second one is the Financial Action Task Force requirement for membership of the organization. Nigeria first applied for membership in 2014, but our application was not considered for lack of political will by the last administration of President Goodluck Jonathan to fight corruption in the country and for failure of the country to pass certain required laws. When this current administration assumed power in 2015, Nigeria reapplied through the Office of the Attorney General of the Federation. The FATF, in its review of the application, observed that the president has political will. I mean, the current administration has political will to fight corruption. They therefore requested that the country, they requested us to pass certain legislation. One of them is the Nigerian Financial Intelligence Unit Act to separate the NFIU from the EFCC in line with recommendation 28 of the FATF on the autonomy of the FIUs.
You know, if I can just
section 1
pardon me, if I can just take you up on something you touched on earlier, saying that, you know, the current agencies like the EFCC, ICPC have to wait for a conviction before they know what to do with those assets. And I'm just thinking with this PCRMA bill, that's the Proceeds Recovery. Let me just be sure, because it's kind of a mouthful. The Proceeds of Crime Recovery and Management Agency bill. Wouldn't this agency, if it goes through, wouldn't it still have to wait for convictions before it also knows what to do with these assets? I'm just wondering, what new thing will they bring to the table regarding the management of those assets?
No, don't mix up things. I even said it that under the current dispensation, because we don't have the civil forfeiture sections or provision in the EFCC Act and the ICPC Act, they use section 17 of the Advanced Fee Fraud Act right now to do civil forfeiture. There's a difference between civil forfeiture and criminal forfeiture. Criminal forfeiture talks about there has to be a conviction before you can go ahead and make a consequential order of final forfeiture. That means that there must be a conviction of a person. But under the Process of Crime Act, it's an action in rem. Action in rem means that it's going to be an action against the property. So whether the person that comes from the country or is dead is immaterial, because we're going to file the action against the property, and the burden will be on the owner, on the supposed owner of that property, to claim that, to prove the source of his income. So in that situation, the burden is not on the prosecution or the prosecutor. The burden is on the owner of that property to prove that he procured it legitimately and through a legal source of income.
But
so
okay,
and that is from the domestic point of view. I was talking about the second view, and that is even more important now, because if we are talking about domestic view, we have section 17 of the Advanced Fee Fraud Act, but that does not satisfy the international requirements. The international requirements, yes, go ahead.
Before you go on to the next point, I mean, I know you've also heard people who argue previously saying, okay, well, what if we then amend that particular act and have these provisions inserted in there? Wouldn't that give it, the requisite platform upon which they can then fulfill that function and by extension meet the international requirement?
We will be back to what happened under the EFCC Act. You remember there was a fusion of the Nigerian Financial Intelligence Act unit under section 1(2)(c) of the EFCC Act when it was enacted in 2003. The EFCC under section 1(2)(c) states that the EFCC shall be the designated Nigerian Financial Intelligence Unit, and that.
Oh dear. Well, sometimes you just reach now, this shouldn't happen, but yeah, we'll just set it out. So, well, Quite interesting perspective they're saying, but perhaps if you're listening in as well, we'll come back to you, Honorable Oladile. Let's check up with Mr. Ivie. Listen to those perspectives in terms of these amendments, because eventually when it does take shape, that coordination perhaps might bring some of these things under certain legal framework. Do you think this will satisfy the impression people have as to the functions, the credibility, and the capacity of the already existing agencies, including the police, the AFCC, and even the SFU, as a matter of fact?
Well, honestly, I do think that the structure of the agency being contemplated is going to cost money. And we have several structures on ground already. But my major worry is that in a democracy, whatever money you are spending will have to be appropriated by the National Assembly. So if we recover loot, if we sell assets, and we have monies accruing from that process, isn't it better to pay such money into the Federation account? Honestly, I would think that the best thing to do is to pay such monies into the Federation account instead of going around to begin to create a whole agency to manage recovered loot. Such monies can be paid straight into the Federation account and then be appropriated and spent with all amount of accountability that a democracy would deserve. That's what I think should happen.
But, you know, it's not just about the funds as well. I mean, those who will tell you, if you go to certain location in Abuja, you see so much of some properties just there deteriorating. And then there's some, I mean, he was talking about they don't have that full legal provision to auction some of those things, or the processes with which to coordinate those assets. So it's not just about the funds, because it appears as though you're talking about the funds alone. Is that the case?
Yes, I was actually looking at the funds, but in our laws already, as it were, we do have provisions that government could use to either sell those assets that have been seized. The moment you go through the judicial process and a forfeiture is outrightly awarded to the federal government, such assets can be liquidated and the proceeds paid into the Federation account. I think that if you go around to begin to create an agency to manage this with laws and all of that, first and foremost, such agencies, they're going to need funds to operate, which we don't even have. Those funds may come out of what is being recovered. But expressly, if we have provisions within our laws to treat these issues, the recovered assets being sold and then the money is paid straight into the Federation account, I think that's a seamless and a simpler way that the National Assembly can also use to appropriate such funds, and accountability can be ensured in the expenditure of such monies.
Honorable Oladile, you have tried to educate us on the entire process of EFCC, ICPC, and the rest of them, but as you very well know, we have at least 14 legislations in Nigeria that try to address all issues around corruption, anti-corruption, anti-graft, and the rest of it. What's the assurance we have that this new proposition will solve the problems that 14 legislations couldn't solve?
Okay, thank you very much. I was talking about the international obligation that Nigeria has. We applied to join the Financial Action Task Force, and the task force has its own regulations, requirements, and guidelines. Definitely, if we have to join, Nigeria is the only country in West Africa that has been given that opportunity to join. And in the whole of Africa, we have South Africa, which is the only member of this FATF. And because of the importance of Nigeria to the international economic community, they feel that Nigeria should be part of it. But in order to join, we have to, this is one legislation, in addition to the NFIU, separating the NFIU from the EFCC, which they said, in addition to passing the Mutual Legal Assistance in Criminal Matters Act, which we have done, the only one that is remaining is the process of crime. And I will tell you why it is different. Now, we are talking about management of process of crime. And the last person that asked me the question was saying that, or maybe Chamberlain said that, why don't we just amend the extant laws to ensure that what the powers they don't have, we give to them? But we have to look at transparency and accountability. The need to separate the agency that recovers from the agency that manages for transparency and accountability purposes. It is not proper for the same person to recover, the same person to manage. Then how do we account? How do we account? How do we ensure transparency? There is also a need for us to create an autonomous funds for development impact, so that when we are going to have this process of crime bill into law, it's going to create a special fund, which is also a requirement of the international community, which is another international obligation for sustainable approach to the management of process of crime. The FATF, for instance, recommends that we should establish an asset forfeiture funds by all member states. That is the regulation, to give consideration to use all or a portion of those properties being confiscated for social development purposes. Right now, assuming any forfeiture that is being done is taken to the central post, which is the federation account, then how do you trace it? How do you ensure that the money is not relooted again? But if we, under the process of crime, we create a special fund where all funds or all looted funds are being kept, and then those funds will be used for special purposes, and under that situation, we'll be able to have outcome measurement. Under that situation, we'll be able to know that we are devoting the looted funds for construction of roads, for provision of health services, or even for law enforcement purposes. And because it is in a separate account, separated from a federation account, we'll be able to monitor it, we'll be able to have outcome measurement. And of course, it's one of those things that is lacking today. And you will discover that anytime we want to get any of those proceeds for looted funds from abroad, we will go into the MOU, because they want us to tell them what you want to use those things for.
I think something else. I think something else that popped out for me from the statement of the AGF was said what happened before now is that those proceeds are scattered, that was the term he used, across the police, the DSS, EFCC, ICPC, and it was hard to get like a clear view of what we really had, the assets we had recovered and how they are managed. And I'm thinking, isn't that also an indictment on those agencies of mismanagement?
It's not an indictment. It's not an indictment. Let me say this. It's not an indictment. As I said earlier on, right now what we use is criminal process, whereby you have to prosecute. There has to be a conviction. If there is no conviction, there is no way EFCC, for instance, would dispose of a property being held under an interim order. An interim order is to ensure that you hold that property as an exhibit until there is a conviction. If there's no conviction, that cannot be final forfeiture. And it is after the final forfeiture that there will be a final order. If there's a conviction, that there will be a final order, then they can dispose. So right now, under the process of crime, as I said earlier on, it's going to be a civil process, whereby it will be faster. It will be much more accelerated than the current process. So the procedure they have right now does not give room for accelerated trial. And that's why you have them scattered all over the place. And then, of course, even after the final forfeiture orders have been given. We need a central agency to manage all these properties. And that's what the AGF is talking about. If the ICPC secures a conviction and there is a final forfeiture, then they will recover the property and then give it to the management agency to manage. And as I said, it is better for us to have a different agency managing than to have a fusion of management as well as recovery in the hands of one person. Of course, there can be some human factors there.
Right.
Hey. So
let's take this to Mr. Richards now, because I mean recently in the whole saga with the EFCC, there were reports about certain property and assets that were recovered and maybe weren't handled well. So Mr. Richards, still on that statement made by the AGF saying that these assets were scattered across all these agencies, and I'm thinking also, isn't that a statement that means some of them were inefficient in that regard? Yes, you have given a background as to how much stolen funds we have, basically saying that it might be too much for them to handle. So isn't that an indictment of mismanagement or inefficiency?
Well, the agencies that are recovering and the agencies in which those recovered loots are being domiciled, whether there are several. The fact that they are domiciled in more than one or two agencies does not constitute an indictment on their part. It will only be an indictment if they misuse those recovered loots. But I think very clearly that there's a need for a proper structure and the proper body, Well, I think there's a need for a proper structure to be in place to properly coordinate these recovered loots. My little concern is that, during expenditure, such funds should also go into the Federation account to be appropriated. Such funds has to be appropriated before eventual expenditure. So whether there's going to be a body that would manage the funds before expenditure should be appropriated. The fund, as it were, would not be said to belong to the federal government of Nigeria alone. We have 3 tiers of government. The state is there, the local government is there. And so if a proper structure for accountability is in place to ensure that the expenditure is even countrywide, then of course it becomes satisfactory. But if you just put it in an agency, they manage the agency and federal government has 100% control over that agency, I think that it will not also go down well with the rest of the country.
Okay, now leaning back to your opening statements about the quantum of stolen assets that Nigeria has, is there a possibility that this agency, this proposed agency, might be redundant in a couple of years? Because one imagines that, wouldn't all these assets be eventually recovered? And so what happens to the agency? Is that a possibility?
That's exactly the point I'm trying to make. That if you create this kind of agency, you're going to need a structure which is going to cost money. You would have a DG or a GM, you would have directors, you will have cars, you would have structures that are going to cost money. And we are trying to get out of the wood. We're trying to get a structure in the country that will dissuade people from looting, and eventually get into a sphere of transparency and accountability. So yes, it's going to be redundant at a point in time. And if that happens, maybe government will have to find some other function for it to play. Or it will just be there, having appropriation from the National Assembly 1 year onto another, and without money for it to manage if there are no recovered loots. I think that the proper thing actually to do, yes, it's good that we have a central purse where all the monies are domiciled, but eventually all that money must find its way back to the Federation account to be properly appropriated by the National Assembly before expenditure. So the concern is very germane, and the concern is just there. It's staring us at the face. At the point in time, this agency is going to be dormant, having nothing to do, and consuming money from the system.
Honorable Oladile, that's one concern that I think you may want to also weigh in on. So, first of all, is the issue of funding. Where is the funding going to come from? Secondly, the redundancy. And thirdly, where will the personnel for this proposed new agency, where should it be drawn from?
Well, actually, I don't have the benefit of listening to Mr. Richards, so I don't know his line of argument. But
those are the things that he has mentioned. Yes, those are the things he mentioned. First is the issue of the fact that he responded to the question that this agency might become redundant if there is no more resources to recoup. And secondly, that of funding of the agency, which will begin to suck money from the system if it still doesn't have anything to do. And then the question that I'm adding, where will the personnel be drawn from?
Well, the three questions can be answered very straightforwardly. I will tell you. First of all, I don't know if, as I suggested, I don't know whether in Nigeria a time will come, and I'll be happy to see that time when there will be no corruption, there will be no stolen funds. Ever since independence, let me say it that way, we've been looting public properties, and they are scattered all over the place. In Europe, in America, all over the place. They are there. So if anybody says that a time will come when the process of crime agency will not have any work to do, no functions and duties to perform, then that's in Nigeria that we are looking forward to. An ideal Nigeria where there will be no corruption. But I don't think that is going to happen anywhere. It's nowhere. I've not seen it anywhere in the world where you don't see process of crime being scattered all over the place. So that I can tell you, the frequency, the regularity, they are there. And today we need it because properties are scattered all over the place. We need it because we need to have this issue of interim orders. We need to have them removed so that we can go straight and have actions in REM against the properties and recover them. So that's number one. Number two, on the issue of funding, I will tell you straight away that I was one of those people that sponsored the last bill in the last assembly that was not signed by the president. And in the bill, there is a particular section there that provides a percentage of the process of crime recovered to be used for the management and maintenance of the agency itself. I think it's about 2.5% of the process recovered from the agency for the management and the administration of the agency. And I think this is fair enough. The agency is not going to draw much money from the Federation account because it's going to be self-administered because there's so much there. There's so much there, and taking 2.5% of the process for the management of the administration of the place itself is enough, I believe, to make them do their work and function efficiently without being a charge on public funds. That's one. Then on the issue of personnel, and just like any other organization, I mean, once there's a new organization, you draw personnel from relevant agencies. When the FCC was first established, we had to draw from the police, draw from even the DSS, draw from other relevant agencies to make the first core staff of the FCC. The same thing for ICPC. So I don't see any problem if this agency is established. I don't see any problem in terms of personnel. I don't see any problems in terms of being in charge on public fund. I don't see any problem on the activities of the agency running out. If that happens, as I said, then we have come to the ideal Nigeria which you and I are are looking for. But until that is done, we have to do what we have to do.
You know, I'll be shocked to see you demarket your product, sort of, in some sense. But you know, there's this court order that has been talked about, asking the government to publish recovered assets for, I think, about 2003 or 2004, and that has not really happened. We're still looking forward to that. So is this proposal also going to solve that, so people can have a view? Let it be transparent. Let people know that this is what we have recovered and this is what we're doing with it. Will this also solve that?
Well, in the first instance, principles of sound public financial management requires that public funds be used transparently. So if people, and of course we also have the Freedom of Information Act that people can use to get information. This agency is going to have in the provision there is a provision for auditing, whereby every year the accounts and the activities of the agency will be audited by registered or by auditors, and then it will be presented to the National Assembly, who will now scrutinize it and keep it open to the public. So if in the process there is a need to make all the inventories public, I don't see any reason why that should not be done, because it's a public agency, is using taxpayers' money to exist and to pay its staff and for the administration. So I don't think there's going to be any problem in terms of publishing. Even the EFCC, the ICPC, at least when I was there as the chairman of the EFCC committee in the National Assembly, every year the audited account of EFCC were being made available to the National Assembly. They will audit their accounts, they will send it to my office, and I will send it to the office of the Speaker. So, and now, in the same way, yes.
Let me raise these issues with you. I mean, some of them came up at the time you were working on this bill. Now, the objectives, several of them were highlighted, but one of them include to harmonize and consolidate existing legislative provisions on the recovery of proceeds of crime. But some of the issues raised by this bill, looking through that, says, if you look at clause 97, which says that this agency shall have the power to coordinate and enforce all other laws on the investigation, identification, tracing, and recovery of the proceeds of unlawful activities, which is similar to Section 7, subsection 2 of the EFCC Act. As a matter of fact, look, they say this is a clear duplication of the rules. And even if you look at Clause 101 of the same bill, there are 17 functions of this agency which are similar to functions or the provisions of the EFCC as provided in the Section 6 of the Act, and the functions where they went ahead and listed them. So the ICPC, yes, the EFCC, even NAPT, several agencies perform this function. So people think that this will be a clear duplication. They still make this point, predicating it on this, that if you just come up with this, it will just do little to change things.
Let me just say this. When this bill was passed last year and transmitted to the president, there were objections from the anti-corruption agencies that we have today, who felt that certain provisions of the bill circumvented their powers. They disagreed with Section 157 of the bill, which states that where a provision of the Act is inconsistent with a provision of an applicable Act, which might mean the EFCC Act, the ICPC Act, the Code of Conduct, and even the NAPTIP Act, the provision of the Act shall prevail, and the provision of the applicable Act shall, to the extent of the inconsistency, be void. Then there is another one, a second reason why the other agencies disagreed. The second reason had to do with Section 162, which deals with consequential amendments and transitional provisions. This repealed some overlapping sections that we are talking about in the ICPC Act, in the NDLEA Act, in the EFCC Act, the Trafficking in Persons Enforcement Administration Act, and even the Police Act, as well as the Customs, which they all found objectionable. They felt that those areas actually should not have been deleted or repealed from their laws, because that will clip their wings. It will not make them to work very well. Although they had their points, but the fact under the construction of statutes, if there's a conflict between two statutes, the statute that most recently took effect, otherwise known as latter in time, controls. Even if both provisions took effect on the same day, then the courts will apply the one the president signed last. For instance, the DSS, the Department of State Security, under its act, was responsible for fighting corruption and financial crimes in Nigeria prior to 2003. But when the EFCC was created in 2003, the functions of the EFCC were taken from that of the DSS Act. But because the EFCC was the latter act, the provisions of the DSS Act became subservient to that of the EFCC Act.
Now, pardon me. Well, pardon my apologies. We need to bring in a lawyer now to just weigh in as well on this matter. Mr. Abiodun Owonikoko, Senior Advocate of Nigeria, joins us. We're able to get hold of him even though he's at the move. Good morning, sir. Thank you for joining us today. Well, I don't know how much of this conversation you've caught, but could you go ahead and give us your impressions of this proposed bill and the functions they're listed?
Thank you so much. Good morning. I must confess, I'm not aware of the details of the bill. I can only go by the excerpt given by the Honorable Attorney General of the Federation. That said, one has to look at every legislation from the perspective of the intent behind the legislation. As you yourself earlier noted, there appears to be nothing new in this bill other than to further amplify bureaucracy. And I say this because we should not appear to be institutionalizing the business of recovery of looted funds, unless you are suggesting that this will become a recurring decimal and a way of life, that we assume that we are going to constantly have a stream of funds to be recovered from looting. So far, most of the looted recoveries that we have observed took place, arose from transactions that took place under the previous regime before the present government came into office. And if you are now institutionalizing and creating bureaucracy and commission, there will be not an ad hoc body, but a body in perpetuity looking for work to do, then there will be no end to looting. I recall that as recently as this year, we still got some recovery from the so-called Abacha loot that took place more than 20 years ago. But this government came on the premise of fighting corruption and eliminating it. I do not think it fits well and actually ennobles them if they are the ones now who are going to create permanent lasting bureaucracy for, not for preventing looting, but for recovering the looted funds after they have been looted. I think the concept is not well thought out.
Okay, but haven't
between proceeds of crime, yes.
Okay, I haven't listened to the AGF's comment as well, where he said that they were just scattered, they just needed coordination. What would you recommend be done to address some of the issues he raised?
You don't need more than an interagency committee that would bring all the recovery loot recovery agencies into a common platform where they can be doing periodic returns. Because don't forget, recovery takes two stages. There is interim forfeiture, which does not allow government to use the assets that have been forfeited in the interim. You only can deal with forfeiture after there has been final adjudication. Apart from forfeitures where there are no claimants, those are cases where unclaimed funds, unclaimed assets. Those ones, once the interim forfeiture time lapses, it reverts to government because bona vacantia. And when that happens, it becomes part of the revenue of the federation. So you cannot have an agency that will be managing that. It's supposed to go straight and be captured in our revenue and assets. We have Auditor General of Federation, we have Accountant General of Federation, and we have the Minister of Finance, who now also supervises budget as well as national planning. Why do we have to create a separate agency that will be warehousing looted funds. For what purpose? Because if they do that, they still cannot deal with the money. It must still go back in the Federation account and then appropriated. Don't forget, any looted fund from government must have arisen from an appropriation in the first place.
How about that?
Before,
yeah. How about that part of the conversation from the AGF where he said that this is a product of something that we need to do to be members of the Financial Action Task Force, that international agency?
Now, what I'm saying is this. This is what we have been saying. We created EFCC, we created ICPC, we created NFIU. After NFIU, we don't need any such agency anymore. NFIU is the one that I know is the requirement. And you saw the problem Nigeria faced when we refused to extract NFIU from EFCC. But they wanted to be independent. But once we have recovered looted funds, once we have recovered looted funds that is going to government, it has nothing to do with the national community. The international community's interest is from prevention of financial crimes and then prosecution, effective prosecution and recovery. Once it is recovered, our law contains provision for restitution. Some of these recoveries not necessarily do not have to go to government. If a private person was defrauded and EFCC prosecutes and recovers, that money should not go to government. That money under our law, under AGA, should go to the victim of the crime. It's only the looted funds from public funds that this issue arises from. It doesn't have anything to do with private economic crime. And if it's a foreign victim that we have, NFIU and EFCC have protocols for repatriating funds that are recovered on their behalf. Will those money now go to this agency? Then we have about 3 or 4 layers of agencies handling the issue of recovery. Are we thinking about the time turnaround for people to even get redress? If at the end of the day, the money will leave EFCC, leave court custody, and then go to this agency again. To do what? I think it's a totally unnecessary distraction. Instead, what will happen? Even this as it is now, that agency is going to be idle until money is fully recovered. So what will they be doing in the interval? They'll be waiting and praying that people continue to lose money so that there will be activity for them to do as a commission. Then you have the commission, you have chairman, you have members. They will have all sorts of honorarium. And don't forget, we are yet to even implement the Rosary report about merging some of these duplicated agencies, which government itself as a policy has accepted. Why are we now going about creating new agencies again when we are even trying to merge and collapse duplicated agencies? I don't see any value in this.
Right then, Mr. Abiodun Wonikoko, Senior Advocate of Nigeria, we do thank you for your thoughts. We also do. All right, thank you very much indeed. Well, yes, indeed. But we also have to thank you, Mr. Evie Richards, for your thoughts as well as Honorable Kaide Oladele, who is a former Chairman House Committee on Narcotics, Financial Crimes, and Anti-Corruption. I suspect that in the days ahead, we will have cause to revisit this matter. So don't worry about that. I know you still have some things to say. Well, thank you all for talking to us this morning.